Can my creditor force the sale of my Utah home? Hi, this is attorney Chip Parker from Blue Bee Bankruptcy Law. A creditor can force the sale of your home in Utah under certain circumstances. First of all, the creditor must file a lawsuit against you seeking a money judgment. Keep in mind that the lawsuit must usually be filed in the county in which you reside, unless you contractually agree to be sued in another state or another county within the state. Next, the creditor must obtain a money judgment against you if the judgment was obtained in another state, and the creditor would have to domesticate the judgment in Utah. The process of domesticating a foreign judgment generally involves filing a petition in the Utah county where you live and serving you with a copy of the petition by hand delivery. The creditor must then follow the prescribed process for recording the money judgment in the official records of the Utah county in which your home is located. Finally, the creditor can commence a foreclosure upon your home, which will result in the judicial sale of your home. Keep in mind that the judgment lien is inferior to prior recorded liens like your mortgage or maybe a tax lien. This means that if your house is sold, the judgment creditor will be paid only after superior lien holders. Also, keep in mind that once the judgment creditor has perfected a judicial lien on your home, you'll need to pay off that creditor when you try to sell your home. Wait, what? You're probably asking yourself, do I have any protections to prevent this from happening? Well, the most common way to prevent a judicial lien foreclosure is by filing a bankruptcy. The automatic stay prevents any and all efforts to collect your debt, including a foreclosure of your home. The bankruptcy court will then determine the value of the judicial creditor's lien using this general formula. Home value minus all voluntary mortgages minus spouse's share of equity minus the homestead exemption equals the value of the judgment lien. Utah's homestead exemption protects the first $42,000 of equity if you're single and $84,000 of equity if you're a couple. If you own your home with your non-debtor spouse and the judgment is only in your name, your spouse is entitled to protect his or her half of the equity, and then you would apply your homestead exemption to your half. If you're thinking about filing bankruptcy and you are concerned about judicial liens, make sure you thoroughly discuss this issue with an experienced bankruptcy attorney.